Well, last year, the Gauteng High Court in Pretoria declaring that the Sexual Offences and Related Matters Act inconsistent with the Constitution and invalid. Now, the Embrace Project is arguing that the provisions of the Act fail to criminalise an accused person's wrongly held belief that the complainant consented to a sexual act. Let's tease this further now and talk to Newzroom Afrika's Zoleka Qodashe, who is in studio with us to explain what we're about to hear before the Constitutional Court tomorrow. Zoleka, good evening to you, and let's put this plainly. A person who is accused of rape, if they reasonably believe that the complainant consented to sex, they could easily avoid conviction. That is at the core of what this argument is going to be about. Am I correct? That's the Sexual Offences Act as it stands.
That's correct, Koli. Essentially, what the applicants argue is that this creates a defense for an accused person to use that argument that they reasonably believed that consent had been granted. But you'll remember that that is a subjective test. So in subjectivity, it's often looking at the intent of the accused person. And in matters such as this, they look at, the criminal court would look at whether the account by the accused person is one that can be believed. But what the applicants argue is that, and it's part of the reading in that was granted by the order of the Gauteng High Court in Pretoria, that an accused person must demonstrate to the court that they took reasonable steps, objectively reasonable steps, to ensure that consent was granted. Now, there's also a test in terms of reasonableness, right? Reasonableness relates to an objective legal standard where an accused person will have to look at the harm that may have been inflicted on the complainant in the matter. So they would look, the court would ask, would a reasonable person in the same position as that of the accused have foreseen the harm that they may have inflicted on the complainant? And then two is that would a reasonable person take steps to ensure that the harm is not inflicted upon the complainant? Yeah. So that is the test. And so that is why the applicants in the matter, one of them who is a rape survivor, in fact, are asking the court to ensure that there is that objective, reasonable test to see whether an accused person must demonstrate to the court that they took the necessary steps to ensure that consent was granted.
Yeah, and I suspect the organization that has taken this all the way now up to the Constitutional Court, they have very good reasons for why they are pursuing this, because in all probability, a lot of people who are accused of rape may have gotten off simply because they argue that the complainant had consented to sex.
That's correct. And particularly in intimate partner relationships where it is an intimate setting and an intimate relationship where the consent is often, an accused person would actually argue that the consent is kind of guaranteed because of the setting that they're in. Yeah. But I think an important aspect of the ruling or the judgment of the Gauteng High Court in Pretoria is the prospective nature of that order, which means it applies only to matters that come after, or rape matters that come after the date of that handing down of that order, which was September 2024. So it has no bearing on any other matters that were rape matters that took place prior to when the order was handed down.
just finally, Zoleka, and I mean, feel free to say, well, in this particular matter, we'll have to wait on the courts. If the Constitutional Court were to agree and uphold the ruling of the Gauteng High Court that indeed sections of the Sexual Offences Act are unconstitutional and therefore invalid, if that were to be the case, what then would happen to those people that are accused of such crimes and go before courts and say they believe that indeed the complainant consented?
So what we often see happen in matters where there's a declaration of constitutional invalidity, if the Constitutional Court confirms that declaration of constitutional invalidity, what we're likely to see is a suspended order of that constitutional invalidity. Then it will be referred to Parliament. Of course, Parliament would then need to remedy the defects of the current legislation. But what we have at the moment is a reading in from the Gauteng High Court in Pretoria. That reading in is an addition to the current piece of legislation, right? Of legislation, rather. So what it does is that it allows for the legislation to be consistent with the Constitution, so that while Parliament remedies the defects, this piece of legislation is constitutional. The applicants have applied for an 18-month period for the suspension order, which means that Parliament would then have 18 months to remedy the defects. An important aspect of this application is that if Parliament fails within the suspension period of 18 months to remedy those defects, they are asking the Constitutional Court to declare that that reading in Section 56 of the Sexual Offences and Related Matters Act will become final. That's what they are asking for. So there is a period, there is an element where the Constitutional Court will look at the reading in. That's something that they will look at tomorrow, the justices of the Constitutional Court. The reading in that has been applied in the statute, but also will send the statute to Parliament for them to remedy the defects, so that there is that element of constitutionality in relation to the legislation.
Thank you very much for explaining that to us so well. Zoleka Qodashe is going to be following this particular story tomorrow. Thanks indeed for that.